Dear participants of this wonderful conference, I would like to welcome you all back again at CPDP, finally after 2 years in physical. I've been attending the conference since 2015 and I'm so happy to be back here again. And I'm also very excited for our today's topic, which I hope is also very exciting to you. Our panel is titled Limiting State Surveillance by Means of Constitutional Law, Potentials and Limitations. But what exactly is this topic about? Namely, in its 2010 ruling on data retention, the German Federal Constitutional Court stipulated that the legislature is henceforth obliged to exercise greater restraint when considering new retention obligations or authorizations. And this in view of the totality of the existing regulations that are already in place. From this, the German law professor Alexander Roßnagel derived a government obligation to examine the proportionality of the overall burdens on civil liberties on the basis of an overall consideration of all government surveillance measures, a so-called surveillance calculus, or how we call it in English, or in German, Überwachungs-Gesamtrechnung. According to this interpretation, there is a constitutionally prescribed maximum level of state surveillance that must not be exceeded. For example, once a certain threshold is reached, the legislator would have to exchange one surveillance measure for another, rather than introducing new surveillance measures. Our panel will discuss two possibilities, possible approaches to a surveillance calculus, as well as the potentials and limitations to them. Questions might include, but are not limited to, how can we record and especially how can we assess the different surveillance measures that are already in place, or what would be the expected legislative effect? Would really the newest surveillance measure not come into effect, or would it be exchanged for an older one? These are different questions on the process of such a surveillance calculus, but there are also fundamental questions. What would be an acceptable level of surveillance and who determines it? Or would a surveillance calculus rather lead to a critical control or to legitimization of even more surveillance measures dependent on the political power balance at place? And finally, what can we learn from this debate for the rest of the EU or even beyond of Europe? Are there any points of reference in EU law or in the constitutional law of other member states that could prescribe such a ceiling for state surveillance? Now briefly on the panel schedule, each speaker now has roughly 10 to 12 minutes to present his or her perspectives on the topic. After each presentation there will be a short opportunity for brief comprehension questions. Afterwards we look forward to a discussion both among our speakers and with you all. And yeah, before I introduce our first speaker, Christian Gemin, I would like to just talk 2 sentences on me. I'm Murat Karaboğa. I'm senior researcher at Fraunhofer ISI and a political scientist, and I'm dealing with technology assessment issues and surveillance and data protection for quite some years. And our first speaker today is Christian Gemin. Mr. Gemin is a legal scholar. He received his doctorate in 2013 on issues of fundamental rights-based technology design. His postdoctoral thesis is dedicated to the fundamental rights implications of digitalization. Since 2015, he has also been entrusted with the management of the project group for constitutionally compatible technology design at the University of Kassel in Germany. In addition, since 2014, Mr. Gemin has also been part of the Forum Privacy Research Consortium, of which I am also a member. And together with other foreign privacy members, Mr. Gemin has been working on the topic of delivering a proposal for such a surveillance calculus. And maybe some of you had it in your bags. We also wrote a short paper on the topic. And yeah, now I'm pleased to hand the floor over to you.
Okay, thank you, Murat, for the introduction. I will give a brief overview of the constitutional implications and the origins of what we call the surveillance calculus or the Überwachungs-Gesamtrechnung in German. The topic of surveillance permeates numerous decisions of the German Constitutional Court. A few examples can be found on the slide and range from automated license plate recognition to the infiltration of IT systems. The focus lies naturally on surveillance by the state. The fundamental rights are mobilized in their function as a defense against invasive practices of the state. The state's duties to protect against private incursions remain in the background. In addition, many decisions do not mention the term surveillance, but are still highly relevant and address both the result and the consequences of surveillance. One particularly meaningful example is the requirement that the individual is guaranteed an interior space in which the individual possesses itself and in which he can retreat, to which the environment has no access, and in which he is left alone and can enjoy a right to solitude. Throughout such rulings, the court draws a line to self-development and the protection of the personality. This can be demonstrated by looking at a ruling from 2004 regarding new enabling clauses for the surveillance of living quarters, where Judge Homan Denhardt writes in a dissenting opinion, "For self-development requires spaces to retreat, in which the individual can express itself without fear of surveillance and communicate personal opinions and sensations with confidence." Surveillance even escalates to a violation of human dignity if a surveillance measure extends over a longer period of time and is so extensive as to register almost all movements and manifestations of life of the subject without interruption and can become the basis for a personality profile. In summary, the risks of surveillance to the development and living out of the personality, and especially the creation of personality profiles, have been made clear time and again by the court and are used as a central argument against the accumulation of personal data by state entities. The road to the surveillance calculus begins with the earliest of these decisions. Its most significant precursor, however, was a ruling in 2005. The case was about the concurrent use of multiple technical surveillance measures in the context of a criminal investigation. The court stated, "When using modern investigative methods, in particular methods that are hidden from the subject, law enforcement must adhere to special requirements with regard to the procedure that take into account the risk potential inherent to an additive interference with fundamental rights." Decision makers are thus admonished to include in the test for proportionality of a measure whether additional surveillance measures have already been mandated or if there are plans to do so in the future. If that is the case, the test for proportionality must be expanded to include an evaluation whether or not the concrete measure that is being contemplated is proportional and, in particular, objectively within reason, even when taking into account these other measures. There are similarities of this approach to the concept of aggregation in the context of the Fourth Amendment in US law, in part with reference to the so-called Mosaic Theory, which was developed with regard to information acquisition of the intelligence apparatus, and which basically states that the situation as a whole and its context must be considered. Still, the court left open when the threshold is reached that turns legal surveillance into illegal and total surveillance. With regard to the cumulative effort of multiple surveillance measures, this means that it is very hard to decide which measure will be the straw that breaks the camel's back. Possible criteria could be the number of measures, the number and type of state entities that are involved, the duration of the application of individual measures, the duration of the overlap of individual measures, the number and the importance of areas of life that are under surveillance, whether highly personal communication is involved, whether special bonds of trust are involved, the combination of multiple modes of coverage, the involvement of spaces that serve as a retreat, or whether both in a spatial and temporal sense, areas remain that are free from surveillance. These criteria are validated by the ruling of the Federal Constitutional Court concerning preventive dragnet investigations, which was made in the following year in 2006. Here the court states, for the legal evaluation of the type of interference with fundamental rights enabled by the power, it is among other factors important how many entities entitled to fundamental rights are subject to how intensive an interference and under which premises this occurs, in particular if these persons have given any cause for the interference. Thus, the design of the threshold for action is significant, as well as the number of affected individuals, and furthermore, the intensity of the individual interference. In 2010, the Federal Constitutional Court had to give a decision on the lawfulness of the retention of telecommunications data by private telecommunications providers. Two sentences sum up the ruling. The court states, the implementation of the retention of telecommunications data cannot serve as a model for the creation of further preventive data retention without cause, but instead forces the legislator to act with greater restraint when contemplating new obligations or authorizations for storage regarding the totality of the individual data collections already in existence. The requirement that the exercise of their freedoms by the citizens may not be totally recorded and registered is part of the constitutional identity of the Federal Republic of Germany. So what the court does here is in essence to draw a line in the sand with regard to a limitless precaution for internal security. Still, it remains unclear where that line is located exactly. Rather, in its rhetoric, the court can be characterized as constantly stating that the line, while close, has yet to be crossed. It does, however, state, as a result of the precautionary implementation of the retention of telecommunications data, the margin for additional types of precautionary data retention becomes significantly narrower, even if by way of the European Union. The context here, of course, being Directive 2006/24 EC concerning data retention in connection with the provision of services and the legal battle surrounding the directive itself, as well as its implementations in the member states. The remarks of the court were then summarized by Alexander Roßnagel with the term Überwachungs-Gesamtrechnung, which again we have translated as surveillance calculus. Roßnagel states, and I quote, "Crucial is a total view of the state of state surveillance. The modern information technology would make it possible to monitor all activities of all citizens comprehensively and completely. The civilizing feat required by constitutional law is to refrain from doing so in the interest of freedom. Hence, going forward, a dual test of proportionality is required. First, on the basis of the effects of the security measure, its proportionate use must be evaluated. Second, and additionally, on the basis of a calculus of all available surveillance measures, the proportionality of this total strain of civil liberties must be investigated. This is to ensure that even with all surveillance measures combined, all activities of the citizen cannot be recorded and reconstructed. Taking into account the severity of the threat that modern surveillance measures pose for fundamental rights, the surveillance calculus seems to be the concept that is most promising to at least ensure a rudimentary overview in the face of complex interrelations and the highly invasive character of modern surveillance measures. The overview can and should inform the legislative process in the field of internal security. The shortcomings and problems of a surveillance calculus and the many possibilities of how to actually implement the concept must not deter from establishing and institutionalizing the calculus that the Federal Constitutional Court demands. This is in spite of the fact that the court has, since its ruling in 2010, not attempted to concretize the concept or even picked up on it in any meaningful way. The reasoning here is that even the intermediate steps of a surveillance calculus have significant value when it comes to the protection of fundamental rights. When it comes to the institutionalization of a surveillance calculus, there are many options available. For example, as a mandatory element of the legislative process or as an independent impact assessment. The preferred variants, in my opinion, would be those that establish the surveillance calculus as a permanent task of an independent institution that is equipped with sufficient funding to actually perform the task in a meaningful way. Only then can an instrumentalization or marginalization of a surveillance calculus, once institutionalized by the lawmakers themselves, be prevented, who, while under the obligation to produce constitutionally unobjectable laws, are of course subject to conflicting constraints and motives. As welcome as the ongoing efforts towards the institutionalization of a calculus regarding surveillance measures by the state is, as clear it is that it would only encompass parts of the surveillance activities and potentials that everybody is subject to in the digital age. Due to comprehensive, if only on a case-by-case basis, access of the state to private data collections, as well as due to notification requirements that private entities are subject to, there is a clear connection between private surveillance and state surveillance anyways. This aspect should thus be included in a surveillance calculus, at least in the long run, or a parallel and more abstract calculus for the private sector could be established. I would like to close with an, in my opinion, very poignant quote by a former Minister of the Interior, Gerhard Baum. He wrote, "Even if the individual measure seems relatively harmless, it is the sum of measures that frightens me and the dynamic that has evolved." And that could just as well be the motto behind the surveillance calculus. Thank you.
Thank you. Thank you, Christian. Do we have any brief comprehension questions? We have like 22 seconds. Go on. Nine seconds left.
Hi. So I was wondering about the place of the calculus in the proportionality test. Would it be something external, like the essence test in Article 52? Would it be part of the suitability subtest, necessity, stricto sensu proportionality? Where would you place it?
Well, it would basically be a second step, in addition, but it would be included in the process of the original proportionality test.
So within limitation analysis, but external to proportionality in a way?
Yeah, that's correct. Yeah.
Thank you.
Thanks. So our second panelist is Michael Kichling. He is also a legal scholar. He works as a senior researcher at the Max Planck Institute for the Study of Crime, Security and Law in Freiburg, Germany. Together with Ralf Poscher, he is head of the project Periodic Surveillance Barometer for Germany. This project specifically aims at identifying and quantifying the cumulative impact on privacy of various surveillance activities undertaken by security and prosecution agencies by means of establishing a periodic surveillance barometer. And more details will be provided by Mr. Kichling himself. The floor is yours.
Thanks a lot. Good afternoon, everybody. It is a pleasure to give you a brief introduction only into the basic ideas of what is behind our current project that is still in the process of being developed. So it is not finished. It is a work in progress. If we speak about the surveillance calculus, then from our point of view, it is important to look not only on the legal provisions, but also to consider the empirical reality of surveillance. Because if we speak about thinking of limiting the surveillance powers, we should first of all have at least a rough idea about the extent of what we are speaking. And from that perspective, our barometer is not seen as, so to say, the calculus. It is meant as a part or as an instrument that can contribute at the end of the day to what is called that Überwachungs-Gesamtrechnung or surveillance calculus. What are the main elements of the concept? So first of all, as I said already, abstract normative views on surveillance powers, that is analysis of the legal regulations, are not sufficient. What we need is an empirically grounded account of the actual status of surveillance, which covers all relevant surveillance activities by the state and also by the different sectors of state powers. It can be police, it can be prosecution, it can be intelligence, it can be other administrative sectors in society. So the focus shall be on the overall burden of surveillance for the citizens through such activities. And our approach now is to install a periodic assessment of the burdens of society as a whole, based on qualitative and quantitative parameters. If we speak about surveillance, two basic forms can be differentiated. On the one hand, there are self-executed production of information, for example, through wiretaping or acoustic surveillance of private premises and so on. And the other, nowadays maybe even more important way to get information is the retrieval of retained data that already exists, data from external sources that can be data stocked somewhere in some authorities, administrations, or what is even more important, private data. And that is why the issue of data retention is so important in our context. And this independent assessment is aimed to provide then an objective scientific evidence for decision makers and the wider public. That can be politicians, courts, the academic community, NGOs, media, and so on. If we speak about parameters or index models, if we look around, we see an array of different indexes. We have the World Press Freedom Index, we have the Corruption Perceptions Index from Transparency International, the Consumer Price Index, the Gini Inequality Index, and what is also an interesting example, I think, is the incarceration rate in a society. The incarceration rate is a very informal parameter. However, it is very powerful. Imagine one day the incarceration rate in Germany would exceed 100 per 100,000 of inhabitants. So that would produce a significant pressure on politics to really decrease this incarceration rate. And that is maybe something that can also be expected from what we call the surveillance index. The basic concept of that index, I don't want to go into detail. It is a six-step procedure. What is important for us is the starting point. The starting point is all relevant data that are interesting. So starting point is the data, and then in the second step, we make a comprehensive analysis of the different and various legal norms that allow to go for such data. Yeah? And that is also important because the purpose, the preconditions, the procedures, the legal safeguards for grasping on such types of data can be totally different, yeah? Depending whether prosecution has such a power, or police has such a power, or intelligence service has such a power. Also, the state laws for police, for example, in the 16 federal states provide for very different preconditions, for example, and also procedural rules. Once we have tested our model on the example of the telephone tapping provisions in the 16 state police laws that we have in Germany, and on a 10-point scale, we had a variance of 10%. Only when we analyze the different legal provisions. Yeah, and then, of course, it is necessary to collect the relevant statistical data. Next important step is an assessment of the intensity, what we also call legal weight of each type of measure. And there applies what also has been mentioned, the double proportionality test. So the perspective is not on individuals, the perspective is on the burden for the society of a whole. What are relevant data that could be considered in a first step of that surveillance barometer? First of all, it's telecommunication data. It is what we call online Durchsuchung. Yeah? That is remote computer search, data connected to the use of telemedia, an area that is very much neglected in the public discussion, at least in Germany, is finance-related data. If we think of all these money laundering regimes that apply from that, we can conclude that at the moment, really the supervision that is executed on all of us, yeah, is the banking information. Yeah? And that I will show you some figures in a few minutes. We will see that is most relevant. Then mobility data, of course. There are very different examples of mobility data that are interesting for the state. And if we think only of the PNR directive of the European Union, yeah? And we have made an estimate based on the year 2000 before COVID came. We had about 260 million people flying from and to Germany, yeah? And that means 260 million data sets that are collected and retained without any reason. Yeah? And that shows how relevant that is. Yeah? And other data that are related to private life. And we can, of course, continue with that list with other examples. The two core parameters are important in our concept. That is the legal weight of the various surveillance measures and the factual weight, yeah? Or in more simple words, the intensity and the frequency of such measures. First, just a few words to the intensity score. As you can see here, we have set up a list of 16 variables based on which the intensity of a particular surveillance measure can be estimated. That is the duration, the purpose of the measure, the question whether there is judicial control over it, the question whether data can be transferred from one authority to another authority, and so on. So each of the variable has a basic value, and then we have also a weighting factor because we thought that the different variables should have a different, also a legal weight from the constitutional perspective. Yeah? And then it goes into such a formula. Details can be discussed maybe maybe later in the discussion. Just to show you two pictures about the frequency and for how is frequency important. Raw statistical data are quite abstract. Yeah? What is also necessary is to translate them into more concrete values. You can see here the lines for telephone tapping and telecommunication metadata in Germany. And we can see the gray one, that is telephone tapping, that is rather stable, whereas the collection of telecommunication metadata is growing. What we then made is to translate these statistical figures on the one hand in the number of orders per working day. That is already more concrete. That gives an idea what is going on in the country, and what is even more important. And that is also a little bit a side effect of the COVID times that we have. The incidence rate per 100,000 inhabitants. Everybody knows that in the meantime, and we can also calculate, of course, the surveillance measures based on an incidence rate per 100,000 inhabitants. And we can see on the left side, wiretapping is more or less stable, whereas the number of metadata that has been collected has doubled. What is even more interesting, here we see the grasp on financial and accounts data in Germany. And here we see really a huge increase. Yeah? And the increase taken, for example, in number of orders per working day increased from some 290 in 2005 into 3,756 in 2018. Yeah? Our incidence rate was growing from 107 to more than 1,353. So the incidence increased by more than 2,000% in that same time span. Yeah? And that shows that in this area, really, there is something going on. So what we see is incidence matters. The mere existence of a legal power on paper does not add on the factual extent of surveillance, because a high incidence rate, of course, increases the individual risk exposure of all of us, of all the citizens. We skip, for time reasons, the last slides. What you can see here is the end result of that parameter. We can then make a regional account. What you can see here is the different indexes for various federal states in Germany. We can do it measure-related, for example, for telephone interception. We can do it sector or purpose-related, and we can do it purpose-related. And the next step can, of course, be to develop such a score also for other European jurisdictions. Thanks a lot.
Thanks, Michael. Wow, thanks a lot. Any comprehension questions? Okay, so let's come to our third speaker, Jane Kilpatrick. Mrs. Kilpatrick has experience as a freelance researcher on a range of fundamental rights issues and holds an LLM in international human rights law from the University of Essex. She currently works as a researcher at Statewatch UK. There she does research on the topics of Frontex, the European Border and Coast Guard Agency, among others. In planning the panel, it was important for us to also solicit the views of surveillance-critical NGOs on the proposals for a surveillance calculus that you've just heard. And I'm very much looking forward to your input, Jane. You have the floor.
Thank you very much. Yeah, and it's lovely to see you all here. This is actually my first time ever at CPDP, so it's been very enjoyable. Yes, so as Murat has said, my research background for the last few years with Statewatch has been primarily related to migration and border control, so apologies if you find my talk a little bit skewed in that area. Statewatch is a non-profit organisation producing and promoting critical research, policy analysis and investigative journalism with a focus on human rights, civil liberties and democratic standards. So in terms of state surveillance, we focus primarily on EU level. For example, we've recently published a report on the development and deployment of biometric identification technologies by police and border authorities in EU member states, and specifically how this relates to the EU's interoperability initiative. And more recently, we published a report, A Clear and Present Danger, Missing Safeguards on Migration and Asylum in the EU's AI Act, which has been a subject of many of the discussions during this week, which have been very interesting. Yeah, we're also starting to investigate, or certainly appreciating the work of others like Petra and Molnar and the Border Violence Monitoring Network and Migrop on investigating the prioritization of digital surveillance in reception centres and hotspots over the improvement, for example, of conditions or the provision of adequate resources for quality of life. And I've just remembered I forgot to start my stopwatch, so I'll do that now.
I can do it.
I know, I like to see, just so I know how much I'm focusing on something. Yeah, so, and also we have a focus on justice and home affairs agencies, particularly Frontex, Europol, and of course increasingly important is EU LISA. We are currently looking into the negotiations on the PRIM 2 proposals, and my colleague Chris looks somewhat more into travel surveillance issues such as like specifically the PNR directive, API, etc. Yeah, so in terms of trying to apply this topic of this panel to an EU context, I was struck by how the paper on the surveillance calculus refers not to just individual systems, but also the combination of systems. And this is presented opposite effects not just on individuals, but on society at large. And this seems very relevant to me, to our work on the EU's interoperability initiatives, and how we see increased data sharing between agencies and states, and how this is also accompanied by legislative attempts to water down the quality of safeguards as well. We're also very interested not only in the legislation drafts and negotiations themselves, but also in where the operational pressure for the changes comes from. And we've particularly looked into the private industry's lobbying of Frontex in terms of surveillance technology, and also the role of Frontex risk analyses and the work of Frontex and Europol together, for example, in the Future Group, in making policy recommendations, which then also lead to increased surveillance. And I think this is particularly relevant. I think I've noticed recently an increased kind of research interest from academia and civil society in states of emergency and how these are used, for example, the COVID pandemic, but also the supposed migration crisis of 2015-16, and how this is used also to justify the introduction of new surveillance measures and to tip the balance, as it were, between different rights. Yeah, okay, so to consider some examples more specifically. So I mentioned the PRIM 2 negotiations. So this is a proposal and negotiations to update the regulation on automated data exchange for police cooperation, and it covers particularly sensitive forms of personal data. So the existing PRIM framework already covers DNA, fingerprints, and vehicle registration databases. The proposal for PRIM 2, and I realise now that I've only ever discussed this with English speakers, and I know I'm saying that word wrong, and I'm very sorry. Yes, this would add, the PRIM 2 proposals would add facial image databases, police records, and possibly driving license data. And the wording of PRIM 2 also waters down obligations on member states requesting data from other states to comply with their national laws, simply to have respect for the same fundamental rights safeguards as would be used in similar applications. And there's also an increased role for Europol in the PRIM 2 framework. And I think trying to link this back a little bit to the question, I think it's not just a case of new legislative measures being introduced, and it's not just a case for new technological opportunities for surveillance, but it's also the interconnection of existing possibilities and therefore the changing context in which different surveillance measures are used that are very important to be taken into account when reviewing the overall effect on individual rights and on collective rights as well. In terms of EU justice and home affairs agencies, we're increasingly recognising their role not only in deploying surveillance technology, but as I said, also influencing surveillance policy. And I think that will be something, the political origins of introducing new surveillance possibilities also needs to be taken into account. Quite recently were published the final report and preparatory documents of Frontex and Europol's future group on travel intelligence. And this proposes a European system for traveller screening, which could include AI technology. So as I said, these were published by us last week, so I have to admit I haven't thoroughly reviewed them. But broadly, the report advocates for automated targeting or screening systems for risk management using advanced information, and wants to expand the available sources beyond advanced passenger lists, passenger name records, and the visa and ETIAS data. And also, very strikingly, the report also proposes a legislative change to combine sources of data and apply AI, and also seeks to position itself, the Frontex Europol Future Group, as an expert consultant on any future negotiations on policy. I don't know why I've written this down, operationally. Anyway, on Europol specifically, the paper discusses the risks of politicized legislation, and this, I think there's quite striking recent example in which trilogue negotiations on new rules for Europol seek to undermine essentially a decision by the EDPS earlier this year that ruled that Europol was illegally processing data on a large scale and required the deletion of that data after a set time period. However, the Council presidency text seeks to permit the ongoing processing of the same information while also limiting the independence of a proposed new fundamental rights officer at the agency. And a letter has naturally been signed by 23 human rights organisations, including State Watch in February, calling on MEPs to remove these new powers. I would really be interested to hear how the barometer or the surveillance calculus or the kind of components that contribute to it could engage with civil society in that way. And I'm very interested to hear more about the political process there. I think I have time to quickly talk about Frontex. So border and pre-frontier surveillance has always been part of the agency's work, but the agency also advocates for its own increased role in managing surveillance tools through its risk analyses and policy recommendations. And this has normalized harmful uses of surveillance. So, for example, Eurosur was set up because a Frontex research paper advocated for more surveillance at the southern Mediterranean border of the EU. And the original political legitimization of this was to save lives at sea, but it's now very openly promoted as a way to prevent arrivals. So this points to the need not only to consider the possibility and deployment of surveillance in different contexts, but also the stated aim and the actual aim, and kind of not just the surveillance happening, but what it's ultimately used for needs to be taken into account. For example, we've recently seen how Frontex surveillance information has been used by the Greek Coast Guard to operate pushbacks at sea. Information is shared with the so-called Libyan Coast Guard, resulting in pullbacks to sites of detention, torture, and mistreatment. And there's also a high association of Frontex aerial surveillance with pushbacks at the land border in Croatia, which are reportedly extremely violent. So how many pages left of notes? Not too many. Okay. To try and consider very briefly and certainly not comprehensively the EU's interoperability initiative and the interconnection of databases, our recent report, Building the Biometric State, looks into how the EU's interoperability initiative and border policies combined together place renewed impetus on biometric registration. That was an interesting noise. Okay. I thought you were using a different bell for all of us in the absence of the hand-rung bell. Yeah, an increased impetus on biometric registration of foreign nationals and increased identity checks. And recent draft conclusions of the Council presidency call for an ambitious implementation of new rules on policing and immigration databases, including on-the-spot biometric checks and introduction. There's encouragement or kind of a legal necessity really for member states to adjust national law to comply with Article 20 of the Interoperability Initiative to conduct these checks and connect the information with the shared EU-level databases, but also then to purchase and manage the equipment necessary, like mobile fingerprint readers and facial scanners. And the Council presidency is very keen that all available data from national databases is added to the Schengen information system. And strikingly, the Commission has acknowledged that new interoperability measures and Article 20 checks could increase the risk of racial profiling and discriminatory selection of persons being checked, but hasn't offered any specific safeguards beyond those which exist in previous legislation. And I think that would be something very important to consider when assessing the burden on individual and collective rights of surveillance. I'm going to skip this little bit. Yeah, okay, and then very quickly I'll say that it's important not just to look at laws, but also at funding for surveillance or surveillance measures. So an analysis of the EU's multi-annual financial framework for 2021 to 27 shows increasingly dramatically increased funding for research into intrusive surveillance as well as other activities carrying significant risks, without introducing transparency and oversight measures in the funding process and conditions for funding. And I think just to end on the fact that it's not just about legal and financial measures, but also I wonder how it can be approached, this kind of operational question. So, for example, throughout this week, I've been in many talks that have discussed how new legislation could provide new opportunities for regulation and safeguards, but even while this legislation and older legislation applies, we still have the fundamental difficulty of establishing like the day-to-day realities of access, of connection, of the ultimate use, and like lack of transparency at an agency level, both for individuals who wish to see what data is held on them, who wish to complain, but also on a democratic level is very difficult. Like it's very high profile how difficult it is, for example, to access any information on the day-to-day access to the ETIAS system, for example, by Frontex. So yeah, I will finish there. I think I've definitely reached my time. Yeah, but I think the main challenges that I would want to consider through this panel are perhaps like not so much, well, certainly are the introduction of new legislation and technical opportunities, but also this question of interconnection and the changing, the kind of use of data collected for one person, one purpose, for example, in the Eurodac database, which would then be able to be used for another purpose through this interoperability framework, and how just a context change impacts rights rather than the introduction of new technology itself. So thank you very much.
Thanks a lot, Jane. And again, a short moment for brief questions, comprehension questions. Okay.
Oh, this one.
Yes, Ivan.
Thank you. Two brief and imperfect questions for the sake of time. The first is, as we know, many state actors outsource their tasks to the private sector, including surveillance-intensive tasks. Have you thought about the involving in the system of private partners or private entities? Because it extends the original system. That's one. And the second one, if there is an absolute limit of the overall amount of surveillance, let's put like this, can you foresee a kind of surveillance quota, and the organization would start trading quotas, like in the field of carbon dioxide emissions or things like that. So, for example, if an organization, law enforcement agency wants to introduce a really very introduced surveillance measure, would they ask another ministry to lower the level or to close down something that is not so important? So 2 questions, the private sector and this. Thank you.
Thanks, Ivan. As these are not really comprehension questions, I think we should discuss them later. They fit very well into the concept. So finally, I would like to welcome Ulf Burmeier as our 4th speaker. He also wears a few different hats, which I would like to summarize as quickly as possible. Mr. Burmeier is co-founder, president, and legal director of the Freedom Rights Society, GFF, a Berlin-based non-profit and non-governmental organization that protects human and civil rights by means of impact litigation. He is currently on leave from his position as a life-tenured judge at Berlin Superior Court. Ulf Burmeier is also fellow of the Center for Internet and Human Rights, and recently, together with the journalist Philipp Banse, he hosts one of Germany's most successful weekly podcasts on politics, State of the Nation. And yeah, we are curious to hear your thoughts on the topic.
Yeah, thank you so much for the kind invitation and introduction today. Yeah, thanks for the opportunity to talk to you today and to discuss some issues that are really close to my heart because they were probably probably among the issues that concerned my friends and me when we started GFF about 8 years ago, because state surveillance was really one of the issue areas that we felt needed impact litigation the most in Germany. We, of course, had sort of private initiatives to fight back against surveillance laws in our country, but we did not have like an established structure, and it was just private initiatives that tackled these issues and certainly brought down some laws, but we thought, let's sort of establish a framework and bring together people who are fascinated by the idea that there should be something like privacy, even defended against state surveillance. So it doesn't come as a surprise that GFF has brought many cases in the realm of state surveillance, and in particular against secret agencies. And so far we have won at least 2 cases. Many others are still pending, and both cases were won basically because the state party in the case could not convince the Constitutional Court in Karlsruhe that the measures were actually proportional. So the proportionality test was what brought down these measures. However, if you read these rulings, they do set relatively tight limits on what states can do, but never has the court completely forbidden any measure, at least in the realm of state surveillance. So state surveillance is sort of pushed back. Some would say just a little bit. Agencies would say significantly pushed back, but there is no such measure that has been completely forbidden. Everything goes, just to a smaller extent. So that's the somewhat frustrating result of our cases. I mean, this is something, of course, that we as a civil rights NGO have to think about, right? And we do win cases, but are we actually winning the war? And that is where the second concept of balancing test comes into play. And this is why I think this is such a promising concept, because every individual measure of state surveillance sort of chips away at privacy to a larger extent or to a smaller extent, but with every single measure, we lose a little bit of our individual freedoms. And that's the problem. Every single measure may be proportional, at least in the way that the Constitutional Court limits it, but that does not change the general problem that our privacy is lost with every single measure. And so I think this balancing test, this holistic view of the burden of surveillance is something that we have to rely on much more, we as GFF, but I think civil society as a whole, and also the political process. And this is why I think these approaches to sort of operationalize this way of thinking are very promising concepts. The intensity score that was just presented to us can definitely be helpful, because we need to better understand which impact a certain measure has on privacy as a whole. But the problem is, we want to define which measures are too much, which measures as a whole, which measures in total present a too heavy burden on civil society or on our privacy. But the question is, what is too much, and who is to define where to draw sort of the red line? You know, this is the problem that I have with these concepts. I think they are very important, and we do need to know what intensity means. And so an intensity score is a nice approach, and it's an important approach, but it still leaves the door relatively wide open to always push back the red line. You know, with every single measure, we can say, well, this measure is proportional, and the overall score is still sort of okay. You know, the overall score is still nothing to really worry about. And this is why I think it's illustrative, and it's really important to have such an intensity score, but we have to complement it, in my view. This is why I'd like to propose a second test that goes back to the Constitutional Court's basic idea why we need such a balancing test in the first place. Because we need such a balancing test, as the Court stated, because we need, from the perspective of human dignity, we need a space that is free from state surveillance. The Court found different wordings for that were presented in the first talk, but the basic idea is we need some space, we need realms free from state surveillance. And this is how I would like to complement this balancing test. We should not only negatively talk about what is too much, what is too much surveillance as a whole, but we should also positively define realms of privacy that may not be tampered with. Realms of privacy that may not be tampered with, that are sort of exempt from state surveillance, because that is what actually guarantees that there are these human dignity spaces, that there are actually spaces where the state is reliably excluded from any means of surveillance. Just to give you a few examples how these realms might be defined, I think one very important realm should be communication between attorneys and lawyers. Because that is something, and the second similar realm should be communication between journalists and their sources. I think it's pretty easy to agree that these communications are really essential for democracy. We do need confidentiality between attorneys and their clients, because otherwise effective defense, criminal defense, is not possible, effective representation in court in general. And same is true for the confidence between journalists and their sources, because sources may not come forward if they have to fear that their communications with journalists may be wiretapped. So just to give you an example, we might even define another realm a bit more global that might be encrypted communications. You know, we could agree as societies to say, no, we think encrypted communications should be completely off limits, because who uses end-to-end encrypted communications expresses his or her wish that these communications be private. You know, I don't think that there's some sort of constitutional basis to say this must be completely off limits. This is something that we probably need to discuss as societies. That should be up to democratic debate and finally democratic decision and vote making. But I'm convinced that a balancing test needs to include this debate. It needs to come up with an idea which spaces should be completely off limits for state surveillance, because and this would sort of lead to a double test. We would have this negative test, what is too much, which is important, which is illustrative, but which brings about certain problems. And we would also have this positive test, are realms of privacy, realms safe from state wiretapping, for example, still guaranteed. Thanks so much, and I'm looking forward to the debate.
Thank you, Ulf. Thank you, everybody. So I have so many questions. Even spelling them out would take the 17 minutes we've left now. So I'm going to start with Ivan's question we've had. So what would you, whoever of you wants to answer that, the question was on the if you have also thought of involving data that's in the hands of private data companies. Yeah.
Maybe I start with that. That is a question that we have discussed for quite a while. And I think the important, so to say, dividing line is when the information goes from the private sphere into or under state control. If we think, once again, I mentioned this example already, the money laundering control. Yeah? So billions of data about all the financial transactions that we are carrying out every day is retained at our banking institutions. Yeah? That is not so impactful, I think. The important moment is when the state seizes these data, yeah? Because then really the measure will have some impact. Yeah? And I think, therefore, if we translate that to the private agency question, as long as the private agency is not carrying out state power, I think we can leave it, at least for the moment, at the side. Yeah? It starts to become problematic when this privately collected data is transferred to the state and has some consequences. We can also see this very well if we look at telecommunication surveillance. Yes, so one example is if the police is looking or is piling up a mobile phone of a person left in a forest, for example. Yeah? So once this measure is carrying out, the case is over. However, if police seizes your mobile phone data, you can end up, in the most extreme case, in prison. And that makes the big difference, I think. So always we must think about it from the end and from the impact a surveillance measure is carrying.
Thanks, Michael. And then I would take the question that Ulf made up now, where to draw the red line. Do you, maybe, Christian, have ideas, suggestions where to draw this red line?
I think the main issue is that we have a moving goalpost. We have to look at the situation as it presents itself in a particular moment, and then we can make a decision. The red line lies here or there in that particular moment, but it may change in the next moment. If you look, for example, at the level of terrorist threat in a particular country, that may vary from time to time, and with it, additional surveillance measures may become necessary, and they will be proportionate because of that added threat level. But the issue that we have is we have had rising threat levels in different areas, for example, in the realm of terrorism, and we have added new enabling clauses for surveillance. But what we are not doing is we are not taking them back after the threat has lowered. So a moving goalpost is a problem, but it should also be instrumentalized in a positive way, so that we measure a lowered threat and translate it into a lowering of surveillance measures.
But I mean, this was part of Jane's talk, where you, please correct me if I understand it wrong, but you highlighted the intertwinedness of surveillance measures, the data flows between different European states, different Europol, and so on, and the multiple uses of the same data. And then I was thinking that, I mean, isn't the more worrisome part of surveillance the effects on individuals? Can we even grasp the level of the worrisomeness of surveillance with such a calculus? Or is it rather just an abstract overview of what's going on, and we maybe need other instruments to grasp the effects on the individual level? What, whoever of you wants to.
Well, I guess the different tests just serve different purposes. On the individual level, we have the proportionality test, which focuses on the individual measures and the individual person that is concerned by this type of data collection, for example, while the balancing tests or the surveillance calculus test looks at society as a whole, because privacy has always had, at least in the German doctrine, has always been a two-pronged fundamental right. There's always the individual dimension, so individual human beings need privacy in order to live freely, in order to live a self-determined life, but privacy also has a very fundamental position in a democratic society, because without privacy there cannot be a democratic debate. You have to gather, as a journalist, you have to gather sources, and as, for example, a union, a workers' union, you have to be free from surveillance in order to discuss issues, for example. So there's all sorts of realms in society where privacy comes into play and serves a general societal purpose. And so I think these tests just have different fields of applications and different, basically, questions that they try to answer.
Yeah, thanks. So we have now 10 minutes left for some questions from our audience, and I already see one person and the second here.
Thank you very much. Great panel. My name is Juraj Seifert. I'm from Vrije Universiteit Brussels here in Brussels. And I'm sorry that some of you are behind the pillar, so you can't see me, and I can't see you. Hi, Ulf. Nice to see you. Anyway, so my first question is for Michael, because I'm in charge of a very similar project to yours here in Benelux countries. We try to measure surveillance, let's call it like that. And so I will definitely try to grab you in the coffee break, but before that, I just wanted
Please do so, yeah.
I just wanted to ask you, how did you manage to get all this data about telco data access or financial data access, because that's something we have been struggling with a lot here in the Benelux, and depending on the country. So what was your method basically for collecting these statistics? And for Ulf, I have a question, or actually maybe I would like to express my concern about this positive aspect that you were advocating, because that reminds me of positive obligations, or the Drittwirkung theory, as it was taken over by the European Court of Human Rights. And I often hear from the law enforcement community, when we speak about privacy, they argue that, but we have a positive obligation to protect other fundamental rights, so we have to invade your privacy in order to protect other fundamental rights. Look at the KU versus Finland, or that's often a judgment of the Strasbourg Court that is being quoted by the law enforcement community, and other judgments of that type, where we have positive obligations to protect the right to life, the prohibition of torture, even the right to liberty and security gets misinterpreted very often for that purpose. So my basically question is, wouldn't it be better if we just stick to the negative obligations, so in order not to create this type of balancing exercises that should not be actually carried out? Yeah, that's all from me. Thank you.
Cool, thanks a lot. I would take the answers now, and then after that get to the second question.
Okay, just very briefly, so I'm looking forward to our discussion later. So the data sources, really getting reliable statistical data, that is a bit of a weak point, because we depend on external support from official statistics. What is well covered in Germany is the statistics on all the prosecutorial measures. However, where we had not much figures in in the past was all the preventive measures carried out by police, but luckily this has changed. So all the police laws meanwhile provide for an obligation for the state authorities to collect and provide data. These provisions came into force 2 years ago and 1 year ago, and hopefully at the end of this year we will have for the first time have reliable police data. And on top of that, we can also profit from a trend in the case law of the Federal Constitutional Court, because the court more and more establishes a requirement for all the state authorities really to make protocols about all the measures, and that can, of course, in the future also be a good source for the project.
Thanks.
Yeah, thanks for the for bringing into play the arguments that law enforcement may be making. I mean, these are no news, actually, right? I mean, this is the basic debate that we are having: privacy of fundamental rights in general versus demands or requirements of law enforcement. And I mean, I've been working as a judge in criminal cases for a couple of years, so I do know that these requirements are absolutely real. You know, this is something that we all have to deal with as the privacy community, and it's really important that these the requirements are named. However, I am not convinced that there is a substantive difference when it comes to the balancing test. You know, the balancing test very generally put between privacy and state requirements. This balancing test is not fundamentally different between the balancing test that we talked about today. So the surveillance calculus, on the one hand, and the realms of privacy approach that I was suggesting as an addition, because in both cases you have the same debate. Should we have? Should government have access to this and that? And I'm just saying that defining certain realms can make it easier and can make it more reliable and can also lead to a more fruitful public debate. Just take the example of the privacy or confidentiality between journalists and their sources. I think it's easier to talk about the question, should this be completely off limits for law enforcement, than talking about which measures can be proportional when wiretapping journalists. What is the threshold beyond which journalists can be wiretapped, or their sources can be wiretapped? Or what is a journalist? I mean, this was one main issue in the case that we brought against the German Foreign Surveillance Service, BND, because they wanted to basically define whole sorts of investigative journalists out of the picture, because they said they are just bloggers, they are just podcasters, they are just sources of sources. You know, I mean, they were coming up with many creative ideas how to define people as non-journalists, right? I mean, this is the sort of problems that you always get when you come up with some balancing test. And so I think the debate is real, but I think it's easier, at least easier to politicize in a way, if you really talk about whole realms that should be off limits.
Thanks, Ulf. So we have 3 minutes left. One brief commentary from...
Just a very brief comment. You can also manufacture the need for surveillance. Think about a situation where a country would decide to erect numerous nuclear power plants. Then those plants need to be secured, not only the plants themselves, but also transport of radioactive material. You would have to maybe supervise or survey groups that are violently opposed against nuclear power. So just by going this particular way, erecting those power plants, you have created a severe need for surveillance, which would not have been there if the country had gone in another direction. We have a situation where the proportionality test would fail us, because there is a need for this surveillance, an objective need, and maybe even the surveillance calculus would also fail us in this situation, because again, you would come to the conclusion, in this situation, under these circumstances, the surveillance is justified.
I think this highlights perfectly the political, societal dimension of what we're talking about. And can we have your question? Only 2 minutes left, unfortunately, but yeah.
Okay, I would like to ask what would be the implications of calculus test for For example, in criminal law context, if we find a surveillance technology which doesn't fit to calculus test, then should we take the evidence directly as illegal evidence found by these technologies? Should we introduce maybe such norms to make sure that the courts don't use that as evidence? Second question, quick question. Jane, what would you think if we apply calculus test to Frontex technologies used by Frontex? Because it implies the impact on society, but which society? Is it going to be like internationalist human society, or how would it end?
Jane.
Thank you.
Yeah, I think the which society is a really good question, and was something I was thinking about throughout the panel and in preparation. Is that like it's very contextual, and like the people affected by Frontex, for example, are very often not EU citizens. Most of all, they are not. They are people on the move, and they're people either unable to enter the EU, sometimes not even thinking of entering the EU, but still surveilled and with their information still used for purposes they don't know about. So yeah, I think that's a very tricky question, really, to come up with a clear answer to, and I think the challenges to that involve this lack of transparency by certain authorities and agencies, and also the fact that often that society won't realise what their data is being used for, or that it's even being used at all. So, for example, Frontex's attempts to use social media to inform border control, like individuals in that scenario wouldn't know at which point they had been affected by that. So yeah, I actually don't know how to quite answer your question, but I think it would be a really interesting way to apply. But I think a fundamental challenge would be this problem with transparency and this continual evocation of the justification of security to impede transparency, not just to journalists in Parliament, but also to individuals. So.
And only very short from my side. So this surveillance barometer is meant as a transparency project. So the aim is not really to be used in a concrete criminal case.
And unfortunately, we have to finish now. But dear audience, dear panelists, thanks for your contributions, for your questions, and have a nice trip back later. And see you next year at CPDP.
Thank you, Nick.